The rights and duties granted to human beings at birth are ultimately resolved into what is called the hukum shari, or the legal rule, which elaborates the meaning of Islamic law. The legal rule is divided into the well-known five-fold division by the jurists. At the extreme end are obligations and prohibitions. Next come the recommendations and disapprovals. Finally, we have what is called the area of permissibility, or ibaḥah, with the act itself being called permissible or mubah. This vast uncharted area of permissibility contains the bulk of Islamic law, like contracts and transactions, as well as all rights, liberties and freedoms that are the source of what today we call human rights. Are human beings at liberty to undertake any kind of act that they like, or is there some kind of check on their activity based on the Sharia? Jurists have different views about the freedoms available in this area. The most widely accepted principle for this area is as follows. The original rule for all things, or acts, is permissibility. A French maxim expresses the idea as follows. Everything that the law does not forbid is permitted. The rule is stated in the initial parts of many constitutions today. In simple terms, this principle means that if, for a contemplated act, there is no prohibiting evidence available from the text of Islamic law or its fundamental propositions, then the act may be presumed to be permitted. The principle may also be explained with a slightly different emphasis. Originally, all things were permissible till the Sharia came and prohibited certain things, required certain acts, and made others permissible. All things that it did not mention either expressly or by implication continue to be permissible. These or other similar explanations are generally deemed sufficient by writers, and they move on after giving a few examples. The position, however, is quite complex, and without hesitation, we can say that this is the most complex of all issues in Islamic jurisprudence. What, for example, is meant by all things? Does it include our inner and outward acts? Was there no liability for human beings from the start? If Allah has permitted most things, because we cannot find an evidence to the contrary in the text, then do we as human beings have the right to prohibit these permitted acts? Whatever arguments we use to justify this, for example, can we declare certain acts as terrorist acts or as money laundering when the Sharia is silent about them? Assuming that the Sharia has permitted us to prohibit certain things under certain circumstances, justifying them as beneficial or harmful. As in the principle of utility, what methodology do we use to declare the permitted as prohibited? Can we use our reason without restraints for doing so? What role does reason have in this area? Are there certain things that are so essential that they have to remain permitted and can never be prohibited? These and a host of other questions surround this issue. It is obvious that to answer many of these questions, a thorough search is needed through the entire literature on Islamic jurisprudence. And even then, the answers may not be found unless one knows where to look. To make matters easy, we will describe the basic ideas that help in understanding this principle. Initially, we may turn back to the covenant that we have talked about in a previous video. This is what Al-Dabboosee, the famous jurist, did, so we will turn to him. We may begin by raising the question as to how the covenant with the Almighty deals with the area of permissibility. The different ways in which the covenant manifests itself for Muslims, as well as non-Muslims, have also been examined in a previous video. This still leaves us with a huge number of human acts about which there is no clearly expressed rule. Have the causes been identified for us by the lawgiver for this area of activity too, or have they been left to human reason? A greater part of Islamic jurisprudence is concerned with this issue. It lays down the methodology for this uncharted area and how it is to be dealt with. We will describe this methodology in the next video. Here we will deal with the issue through a rational argument. According to Al-Dabboosee, all intelligent beings agree that all things that are not visible to the senses are discovered by rational evidence, and everyone uses his reason for his own welfare. Even the transmitted sources are not understood without legal reasoning. Akal, or reason, is, therefore, a proof recognized by the Sharia. In fact, he deems it an independent source of proof. How does the rational evidence deal with the concept of ibaḥah, or permissibility? What are the things that must always be permissible? What are those that must never be permissible? What are those that are somewhere in between? Finally, how do we understand the principle of permissibility with which we began the description? Al-Dabboosee begins with the question as to what are the things that must always be permissible? Reason tells us. He says that the following things must always be permissible. First, all acts by means of which the existence and subsistence of life are ensured, like breathing, eating, drinking, these must be permitted, at least to the extent that ensures survival. Second, all acts by means of which a person can defend his life from things that threaten life, like external calamities and predatory attacks. Third, things by means of which the human species will continue and spread, like reproduction and the union of the male and the female. Fourth, all acts by means of which the training of the human child takes place after he comes into existence, like care and custody of children till such time that they can survive independently. The needs of the human child are special as compared to all animals. Thus, reason considers all those things good by means of which survival of a person is ensured. Survival, then, is the ras al-mal, or the capital sum, unless manifest evidence appears that says that giving up on life is better. Survival also requires those things that will strengthen the continuation of life and defend it against external threats. It is, therefore, necessary that survival be considered good, and the minimum level of good is permissibility. The same applies to the survival of his progeny. Allah has ingrained certain desires and needs within the human body that compel procreation, and this is what man has in common with all animals. Although unhindered procreation may lead to the survival of the human race, just as it does in the case of animals, the needs of the human child with respect to care and training are mostly through the males and under their supervision. This differs from the similar needs of the animals. Accordingly, though the governing principle, already mentioned, calls for permissibility in these things too, the external requirements of upbringing and the existence of a family. The rule selected is, the initial rule for sexual activity is prohibition. This is then permitted by the Sharia with conditions that are best for raising a family. The rule of initially prohibiting sexual activity for humans actually helps in the survival of the human offspring. Without a family and adequate support for the mother, the survival of the human offspring is threatened. In addition to this, even the rule of the hereafter requires that humans keep their lusts under control. The rule, then, is that survival of the human race is the compelling requirement that imposes the requirements of permissibility. And due to certain external requirements, a rule of prohibition is imposed from outside that regulates sexual activity. For survival itself, permissibility governs. It is to be noted that this is how Al-Dabboosee established the purposes of the Sharia called protection of life, or hifz ala an-nafs, and protection of progeny, or hifz ala an-nasl through reason. And these two are also established through the texts of the Quran and the Sunnah. Al-Dabboosee points out that the permissible things related to survival and reproduction of the human species sometimes become obligatory when viewed from the perspective of deen or the religious system. Deen itself needs the survival of the human species for a purpose and for the betterment of human beings, for Allah is above all needs. These obligatory acts are eating, drinking, breathing, protection from the evil of the aggressors and of extreme cold and heat. If these are neglected, man would perish. This is an idea that Shatibi was to take up 400 years later. Likewise, reproduction is also something that is required by deen for the survival of the human race up to the Day of Judgment. Al-Dabboosee takes up next the discussion of things that must always be prohibited. He says that reason requires some things to be prohibited. These are, first, belief in Taghut, that is, idols, false gods, and Satan. Second, belief in that the world is created for the life of this world alone and for serving hungers, lusts, and desires. Third, the denial of a creator. Fourth, denying that we have been sent for some kind of later recompense. That is, saying that the world is created without any purpose. The opposite of all these things is obligatory. Al-Dabboosee then discusses things that may possibly be permitted, but not necessarily. He says that there are 4 types of things that may possibly be declared permissible according to reason. However, they are not necessarily permissible. so that it may be possible to declare them prohibited when in evidence. From the Sharia or from reason, declares them to be prohibited. The four types are excesses. These are, first, the pursuit of the means of survival over and above what is necessary for survival. Second, the gathering of wealth beyond need, especially wealth of one type. Third, adornment to the extent that is beyond what is necessary for reasonable family support. Fourth, sexual intercourse that is beyond the need of reproduction. These permissible things are not necessary on the basis of reason, and the conclusions of reason are usually not turned down by the Sharia, as both are proofs. It is for this reason that the Sharia has sometimes prohibited parts of these four things, and sometimes it has not. The jurists have disagreed about the issuing of a rule for these four things merely on the basis of reason. Their views are as follows. Some of them said that we are not to concern ourselves with these things, because Allah has not called upon us to do so, nor does reason call upon us to do so. Some of them declared all such things to be prohibited till such time that permissibility is established by means of an evidence. Some of them suspended judgment, that is, they were not sure as to what type of ruling they should issue. The Hanafi jurists said that the initial rule for these four things is permissibility until an evidence of prohibition is adduced. The second view among these jurists is that all things are initially prohibited is based on the opposite of the main rule. Thus, their rule is, the initial rule for all things is prohibition. These jurists maintain that everything in this world belongs to Allah Almighty, and it is He who will tell us what is permissible for us. Thus, the initial rule for another person's property is prohibition. They maintain that there is no evidence beyond basic survival, which is permissible due to necessity. This necessity permits survival to the extent of need, and what is beyond that stays prohibited. The rule for these jurists then is that everything stays prohibited until we can find an evidence from the Sharia for permitting things. It is important to note that we preferred this as a methodology for the Islamization of laws. In our book, Theories of Islamic Law, the third view, out of the four above, upholds suspension of judgment. These jurists maintain that the evidence of reason implies both permissibility and prohibition. It is for this reason that the Sharia has sometimes prohibited things belonging to these four categories, and at other times it has permitted them. The Sharia does not usually oppose the evidence of reason, but the very fact that it has laid down different rules is that in this area, the mind has its limits and it cannot fully grasp some of the interests. The net result of this view, too, is that the Sharia must be consulted to the maximum before a ruling of permissibility can be issued. For the fourth view, which is the view of the Hanafi jurists, Al-Dabboosee gives the following arguments. First, anything that Allah has prohibited, He has done so for our maslahah, or interest in welfare. Thus, He has prohibited unlawful sexual intercourse insofar as it leads to the ruination of progeny and the rearing of children. He has prohibited extravagant consumption insofar as there is injury to the self in it. He has prohibited the wasting of wealth insofar as this leads to prodigality. He has prohibited the drinking of wine or khamr as it leads to defects of the intellect and prevents the remembrance of Allah. He has prohibited gambling as it leads to the wasting of wealth and to enmity and hatred. He then says that Allah has permitted many of these things, except sexual intercourse, due to duress and necessity. He argues that this established that prohibition coming from Allah, the Exalted, is like the prohibition by a physician for the patient, which is for the betterment of the patient. Further, the physician permits some patients to consume certain things as compared to the others, depending on the state of the patient. This type of prohibition indicates that the initial rule is that of permissibility. In short, Al-Dabboosee upholds the principle of ibaḥah in the following form. The initial rule for all things is permissibility, unless an evidence indicates prohibition. This brings us to the end of the general arguments given by the brilliant jurist Al-Dabboosee around 400 of the Hijra or 1000 AD. It is from these descriptions and arguments that a methodology arose for regulating the vast area of permissibility in which all rights, liberties and freedoms that can be termed human rights. This methodology will be described in the next video.